Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Good afternoon or morning. Just going to do a quick share. I was dealing today with a medical provider response to a client's first party high-tech HIPAA request for his medical records. They happen to be mental health records. But anyway, they were very prompt in responding to him, saying that they had to decline providing the records because he did not state a purpose he wanted his records in his HIPAA request and release. Now, aside from the fact that I don't think he's obligated when it's a first party request to give a purpose, so I don't think they can demand it of him. But I don't have the time today to go find out where I knew that from, which would probably be either in the HIPAA statute itself, or it might have been a statement by HHS. I don't know. That's something I got to look into. But in any event, it did remind me to start looking a little bit. So I put like 10 minutes in. But here's something that I really wanted to share, because I hear so many of you and my clients get really, really upset because there are so many errors in the medical records. There can be outright untrue things, inaccuracies. Sometimes it's from cut and paste. Sometimes it's mixing up people. Sometimes it's just flat out misinformation. And if it's material, it could be damaging to their, in theory, their future health treatment, but also to their legal case. So what is the deal about when that happens? You do have an absolute right, I think many of you might know this, to demand, or I should say request, that the medical provider fix the inaccuracies. So how do you go about doing that? Well, generally it's got to be in writing. So I'm just going to give you a little blurb that was provided by a company or a website called medsafe.com. And I thought it just kind of reiterates this. It says, when patients access a medical record and discover information they believe is inaccurate, they must file a written request for the record to be corrected. And I believe this is under HIPAA. The covered entity must then respond to the request within 60 days. And I realize that might seem like a long time, guys. It may take an additional 30 days, but must provide a written explanation for the delay and a date of completion. So if you want your medical records corrected, what I would suggest, obviously you have to do it in writing. And I would probably attach the actual pages and circle what's wrong and explain, why this line is wrong and what would be the accurate statement. I did this once. I think I didn't even do it in writing. It had something to do with my child and pets in the house, and my child had asthma. And there was a mistake that I thought was material because it could look like we were being remiss with regards to keeping our newly diagnosed asthma child out of harm's way with close proximity to animals. Anyway, it did get changed. But what they tend to do is say something like, patient's mother stated that this was incorrect, and that in fact the animals are kept in a separate location, blah blah blah, or something like that. So obviously they cannot attest to whether my animals, where they are. They can only report what I reported, since that's something that happens at home. So for more medical record statements, and it could be whatever it may be. It could be something that they say you said that you didn't say, or they misunderstood what you said and wrote it down wrong. And in some shape or form, it's not favorable to you, or it could be unhelpful or damaging or whatever. I'd go ahead, I would probably send it in a way where I have confirmation of how it was sent. I'm thinking by fax is fine, and then you have a fax confirm. and then diary that date so that you look at 60 days and see if they've responded to you. And if they haven't, perhaps that would be something that would be maybe keep nudging them. But now you've proved that you've tried to get them to correct it yourself, and then maybe you can go and take it up the line. But I think when it's something very material, you probably should do it, because that's going to stick in your record for years. And depending on the nature of that inaccuracy is how important it will be to you to get it fixed. So anywho, they do have a deadline to respond to your request to correct the medical records. If you do it only verbally, I think most people are going to be out of luck. You'll be mentioning it to someone who has no clout, no authority, and no power to do it. So if you do it in writing, it probably goes to the correct office, because I think they know they can get in trouble if they don't respond. I mean, a HIPAA violation, perhaps. Okay. Ciao for now, guys. Later. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hey, so let's talk about being a Social Security disability or SSI claimant, and you have a burden of producing evidence for the SSA to make a determination under its rules as to whether you are disabled, and otherwise meet the criteria you have to meet to receive benefits. Okay, so as you probably know, on initial consideration and reconsideration, the SSA will generally assist you in getting that by ordering all the records of the providers that you gave them full detail for contacting and timeframes when you saw them. It's really helpful because then you don't have to get them. And the SSA actually pays whatever the arranged price is between the SSA and the providers under the law. So it's nice that you don't have to do that. And they pay for it. Now, there comes a point where sometimes you do have to get involved and be proactive on your own case. And you'll know it if you're paying attention to your case and you realize that the SSA didn't get something, or it may have tried and the doctor isn't forthcoming, whatever the case may be. And now you have a deadline and you need to get that stuff in. So you request your records on a HIPAA form of some kind, and there are various kinds to get your records. There are times when some providers, I don't know if it's out of ignorance or it's out of, I don't know, they don't think anyone's going to hold them to it and they just don't provide the records, or they want to try to charge you an illegal amount for the records. Now, a legal amount can vary depending on states and also depending on the method in which you requested your records. So some people use the full protections under HIPAA, meaning some claimants and patients, the full protections under certain aspects of HIPAA that provide for access and affordable access. Generally speaking, if you request your records under those provisions and ask that they be sent to you electronically to the email of your choice or the fax of your choice. The email could be where the records are sent in PDF or by a download link. But in any event, all of those methods are digital or electronic. They are not paper, copy, ink, print, mail, and charging $1 a page as such, or whatever the crazy amount may be. And of course, there's more labor time that would cost that office. Often the offices don't do it themselves. They have a third-party vendor whose business it is to do this. And of course, they want to get paid. So if you have requested the records and you have reason to believe that you are being overcharged, and this would happen if you use the high-tech HIPAA access rules under HIPAA, and they're trying to charge you something more than, say, $6 to $10, it might be that they're violating. So, and also they have a 30-day generally time limit. I know that's trying to get changed. Some people are trying to actually shorten it. I don't know if that's a good idea, but nonetheless, if they don't meet the deadline, and you're running out of time, or they try to overcharge you and they make your records illegally charged. Whether or not you come up with the money to get it, I would argue that that's a violation. Anyway, sometimes they make it so much that a lot of people just walk away from the records and then they can't pursue whatever is in their life that they needed those records for. Okay. It doesn't have to be Social Security. It could be a plethora of other things. The rule is if you want them as a patient, you get them. And if you want them in an electronic format that doesn't cost diddly for the provider, you get them at a very, very, very low cost if they're going to choose to charge you at all. So if all of that gets violated, and that'll take a little due diligence on your part to find out, but I've given you a few hints right here. The avenue, if there is a HIPAA violation, and you have to, again, check out those rules, you can file a complaint with the Office of Civil Rights. That's federal. And they enforce HIPAA across the board. Now, they're not going to be your lawyers and step up for you in particular, generally speaking, which is unfortunate. That means people are still hanging out to dry. But once in a very blue moon, the OCR will sanction a medical provider. I presume that's because they've gotten more than one complaint. Or maybe it is one big bad complaint. I don't know. Remember, they would go after them if they violated privacy rights as well. Here, we're not talking about that. We're talking about your right to access under those privacy rules, you as the patient. So I just want everyone to be aware that you do have the recourse. It's very, very quick and easy. It's like a 2-page form that you can literally fill out and email right to OCR. They give an email address for that as well as a fax, and I'm sure you can mail it if you prefer. But that's how super quick it can be. It can literally be 5 minutes of your time. File the complaint. Make sure you, add the proof of what you're saying if you have it. And that might be a way to, get some of the more abusive providers, of which there are far too many. Just had one today, trying to extort some funds out of a patient, and it's kind of sickening. But until, you start forwarding those issues onto the OCR, I don't see it improving. So I urge everyone to consider doing it. If you are being abused and contacting the office or sending a second reminder to them of their obligation to send it to you is ignored. Or they might respond to you and say, you have to send us this much money, or they might say, no, you have to get a lawyer and have a lawyer send it. All of that is false. And I would think even urging you to do that would be violative in and of itself, aside from the fact that they haven't sent you the records. So just something to look out for. Office of Civil Rights complaint. It's super, super simple to do. I have a copy of the form on my computer for those who need it. But anyway, take that under your hat. I don't yet know of a niche boutique law practice that does federal, has a means or a method of putting into their business model, being able to represent patients who are under the abuses of medical providers in this way, or the vendors. But the vendors, the medical provider is responsible for the behaviors of the vendor. So anyway, until that comes to be where a boutique practice starts to get involved in there, can make it into a viable part of a practice that can at least break even. There's got to be some way. The only resolution I'm seeing is OCR or state medical boards potentially. Other than that, right now, I can't really think of anything else except maybe filing a small claims suit, but I don't know if that would work or not. We'd have to do a little delving there, but the easy one is OCR. It's not going to probably resolve your issue, but it might start building a file against some of these abusive providers. Okay. All righty. Thank you so much, and hope it helps you. Bye.